So you want to know what's going to happen at your arraignment hearing or an arraignment hearing for a criminal case in Washington State. Are you charged with a crime? Do you know somebody who is, or are you just interested in the criminal law? If so, this is the video for you. My name is Lance Fryrear, and I'm a defense attorney in Linwood, Washington, and my criminal defense law firm has been defending people charged with crimes all throughout Washington State for more than 20 years. And we have to go to a lot of arraignment hearings. So in this video, I'm going to cover three things. What is an arraignment hearing? What does it mean? 2, what's likely to happen at your arraignment hearing? And 3, a way that you can get out of that arraignment hearing in some situations and not have to miss work and go to that first court hearing. So I'm just going to jump right into it. What is an arraignment hearing? Well, an arraignment is the first official hearing in a criminal court case. Not just after an arrest. Sometimes you can get arrested and you don't get charged right away, but after you're charged, the court is required to arraign the defendant. And think about arraignment as being told about the official charges against you, what the maximum penalties are and what the minimum penalties are, and also entering a plea of guilty or not guilty. So it's not like a traffic ticket where you just show up for one court date and say your side of the story, because some people think that. It's a type of hearing where you're simply informed of what you're charged with, you're told about what some of the consequences can't be, and you enter a plea of guilty or not guilty. And the secret is the court will only take a plea of not guilty because they don't want you pleading guilty on an arraignment calendar. It's not set up for that. And you don't want to give up your important constitutional rights without an attorney. And most people will not have an attorney by arraignment. So number 2, what does the arraignment hearing actually look like? I'm filming this in, August of 2021. So right now, a lot of court is by Zoom because we're at COVID, right? COVID is still going on. So if a court hearing is by Zoom or if the court hearing is in person, it looks pretty much the same as far as what you tell the court, but it's a little bit different for paperwork. So assume that you go to court in person, you're going to walk in. It's not going to just be you. There's going to be 10 other cases, maybe 20 or 30 other cases, even depending on the court that you're in. And you might have an attorney with you, which is a good idea, or there might be an attorney of the day standing in to advise the general public, or there might not be a defense attorney at all. You'd expect to see a prosecutor there in most cases. That's the person who's against you. And you'd expect to see a judge and often a court clerk. So they're going to go through the court calendar, all the people that were there one at a time, and they're eventually going to call your case. Once they call your case, you're going to step forward to the court, and the court's going to say something like, Mr. Smith, could you state your full name for the record and spell your last name? Do you understand that you're charged with DUI or domestic violence, whatever that is? Then you'd say yes or no. And they'd inform you of the maximum penalties, the minimum penalties, and then ask you to enter a plea. And the plea will typically be not guilty. Then, sort of the scary part is the prosecutor gets to ask for conditions on your release. The judge is going to ask the prosecutor, hey, do you want to let Mr. Smith go without having to post bail or money to get out of jail? Or do you want to ask for bail and make him go to jail right now and post money to get out as security for the public and security that Mr. Smith will reappear? So the prosecutor is going to say their part, and then if you have an attorney with you, they can either agree to the conditions if they're standard conditions, or they can argue against what the prosecutor wants. What are standard conditions? In most cases, standard conditions are we're going to release you without posting bail. You have to promise to come back to court. You have to promise to stay in contact with your attorney, and you have to promise not to commit any new crimes. And if you do any of those things, we're going to revoke your release and put you in jail. And certain other types of cases might have special things. DUIs might be don't drink and drive, domestic violence, assault. They might ask for a no contact order where you can't go home. So it's pretty serious. You need to get an attorney if you can, but this is what to expect at the arraignment. So after you've entered the plea and the court has set conditions, then the court's going to give you a new court date, and hopefully you're going to go on your way and then come back with your next court date, and that one's called a pretrial. So that's what an arraignment looks like in person. On Zoom, it'll sound the same. It'll just be a little different. You should keep your camera off until it's time for your case to be called. Once they hear your case called, you can unmute and turn on your camera, and then it'll go pretty much the same. And any paperwork will typically be sent to you in the mail because you're not there to sign any paperwork in person. So thanks for sticking to the end. Number 3, do you have to go to the arraignment? Is there a way you might be able to skip that first court date? Well, if you get yourself a private attorney, the majority of cases that are non-felony, the majority of them, your attorney is allowed to enter a not guilty plea for you and waive your arraignment. The exceptions, broad exceptions, are DUI type charges, DUI or physical control. We can't waive the arraignment there because the court needs to consider putting an interlock on your car and ordering you not to drink or drive. And also we can't waive domestic violence type arraignments because in those situations, the court has to consider entering a no contact order on you. But in many, many cases, thefts or regular non-domestic violence assaults, hit and runs, all types of, other type of charges, we are allowed to waive arraignment. And that's really good because you don't have to spend time going to court for the first court hearing. The court really doesn't get a chance to set conditions on you, and it's just a smoother process. And the secret is the court sort of wants us to waive the arraignment because it speeds up their calendar because there's a lot of cases they have to handle. So remember, you have to go to arraignment. If you don't, they're going to issue a warrant for your arrest unless you have a private attorney who is able to waive the arraignment and then confirms it got waived and then confirms that you don't have to go. So make sure you show up, but this is a reason to get an attorney early. You can have a better result, and you can also possibly go to court less often. So I hope you found this helpful. If so, I hope you can like the video and maybe subscribe to the station so more people can get information they need. And more importantly, if you have questions about arraignment or you have a criminal charge with an arraignment coming up, you could give my office a call. Again, my name's Lance Fryrear. We've been defending people charged with crimes for more than 20 years. We'll listen to what happened. We'll see if it makes sense to get involved, and we'll be there for you. Thank you.